Hi everyone, and welcome to Rouse's podcast series, IPIQ. These podcasts aim to provide analysis and insight into intellectual property law across the Rouse network. In today's update, we'll be looking into bad faith filings in China and reflect on the practical impacts of the Fourth Amendment to Chinese trademark law since it's come into effect in November 2019. Today I'm joined by Melvin Mei, our trademark expert in Shanghai, to answer some of the more frequently asked questions on this topic. Welcome, Melvin.
Thank you for having me here today.
Bad faith trademark applications have continued to play a large problem in China, and subsequently one of the key amendments which was unveiled is that trademark can only be registered for purpose of use. This is meant to tackle the problem. Taking a step back though, Melvin, what do you think are the reasons for the high numbers of bad faith filings in China?
Thank you for this very good question. I think there are a couple of underlying reasons as this does not happen overnight. First, China is the first to file country rather than a first to use country. Filing and keeping a large number of trademarks in force is simple, not costly, and do not require actual use of the marks in the absence of non-use cancellations filed by third parties. Second, trademarks can sometimes have great value. Trademark squatters are motivated to sell these marks back to those who need them in pursuit of money or other illegal benefits. Third, all trademark laws and regulations are not specifically designed to combat malicious trademark applications and trademark hoarding.
So can you let me know how exactly is registration for purpose of use defined? How do you judge the intention of the filer?
The most significant change to the China trademark law in 2019 is its amendment to Article 4, prohibiting applications filed in bad faith without intent to use. This allows the China Trademark Office to refuse malicious trademark applications during its substantive examination. The law also made changes to Articles 33 and 44, which allows for oppositions and invalidations to be filed on this basis. On the old law, this is not possible. Both the registration for the purpose of use and bad faith are not clearly defined by the law. The State Administration for Market Regulation later issued the several provisions on the regulation of trademark application and registration behavior, which took effect from December 1st, 2019, and provide some guidance on the factors to be considered in applying Article 4. The most important factor is the number and the nature of the trademarks filed by the applicant or its related parties. We need to take a closer look at whether these marks are identical or similar to famous marks, trade names, or personal names of others. The second common factor is the applicant's industry and business status. Earlier decisions are also very important. Any effective administrative and judicial decisions in which the applicant has been found to have engaged in trademark bad faith filings or infringements would be strong evidence in support of cases.
Now, it must be likely that there are instances where two or more parties apply for the same trademark at the same time. What's likely to happen in this instance?
If two parties apply for the same trademark for identical or similar goods on different days, the party who filed the mark first will be entitled to the trademark rights. If they apply for the same trademark for identical or similar goods on the same day, then the trademark rights goes to the party who used the mark first, subject to presentation of evidence of use. If they started using the trademarks on the same day or none of them has ever used the trademarks, then they can negotiate and file a written agreement with the China Trademark Office. In case of failure to negotiate, the eligibility of applicant will be determined by drawing lots.
So does this amendment now change the trademark system from a first to file to a use-based system?
No, China's trademark registration system remains a first to file system. This has not been changed. This means ownership of a mark still goes to the person who files first. But this amendment is a very good supplement, balancing the efficiency of a first-to-file system and the need to combat the proliferation of bad actors who are very good at playing the system for personal gain.
Since coming into force, How has the amendment been relied upon by the Trademark Office, and what have been the outcomes?
Our experience has been that the trademark authorities in China are more willing than before to consider bad faith evidence and make it an important factor when deciding cases. As a result, we have won a growing number of cases in which the marks are not that similar, goods are not that related, but the bad faith of the other sides is blatant.
How does this affect then a brand's defensive filing strategy? Would you still recommend that brand owners file defensively?
Balancing benefits and costs, I would still recommend that brand owners file defensively, especially for those important house brands and where infringements and bad faith filers are rampant. But this is not the only thing brand owners can do or should do. As you know, defensive registrations are vulnerable to non-use cancellations. I also know that many brand owners are experiencing budget cuts in this COVID-19 situation. So a more sensible long-term recommendation is that brand owners accumulate evidence of use and reputation as their day-to-day practice to the point where their reputation will be high enough someday in the future to allow the mark to be protected across classes as a well-known mark.
So, what is the role of a trademark agency, and why was there a need to enact an article regulating bad faith filings by trademark agencies?
A trademark agency should be a professional service provider who helps its clients with all sorts of trademark matters, from filing and prosecuting trademark applications to enforcing trademark rights on the register. However, a small fraction of trademark agencies are utilizing their knowledge about trademark laws and systems to make illegal profits. This is partially because of the lack of regulation regarding trademark agencies compared to law firms. They sometimes work with bad faith filers. What's even worse, we have also seen some trademark agencies who are themselves bad faith filers. They set up a number of companies to be used as trademark applicants, and they control these companies behind the scenes. As you may know, under the new law, if a trademark agency knows or should know that a trademark application instructed by its client is to be filed in bad faith without intent to use, or infringes prior rights of others, it should not work on the client's instructions. Otherwise, it will be liable for administrative penalties, including warnings and fines.
What actions have authorities been taking since the enactment of this provision on trademark agencies?
Let me just give you an interesting example. We detected a bad faith Chinese trademark agency located in Guangdong province. It establishes a bunch of US shell companies adopting the company names of globally famous multinational corporations. It also squats the marks of the genuine companies and other prior rights owners in the name of these shell companies in China. This is what we've never seen before. Since these shell companies' names are identical to those of the genuine companies, and the address of the company is in the US, where most of the genuine company originate or set up offices, the squatting activities are hardly noticeable but could cause serious damages to the IP asset and reputation of the genuine companies. To address this very serious problem, we sent a complaint letter to the China Trademark Office, drawing their attention to the bad faith behavior of this trademark agency and requesting the bad faith behaviors be stopped. As expected, this does not turn out to be a straightforward case. After many rounds of communications with the trademark officials and as a result of our collective efforts with brand owners, eventually this trademark agency was severely punished by local market supervision administration.
And then, what are the limitations?
Compared to the general public and brand owners, trademark agencies are composed of trademark professionals who have much more knowledge and experience in terms of laws and practices. If they want to do something illegal, they can do it in a manner that is not easily noticeable. The current laws and regulations are less equipped to deal with the bad faith trademark agencies like the one I talked about just now. And this always requires us to push the boundaries of the law and think outside the box.
So, Melvin, what do you think will be the long-term consequences of this amendment?
In the long run, let's say 3 to 5 years from now, we hope to see, first, less bad faith filings because many will be refused by the China Trademark Office and many be successfully opposed or invalidated by genuine brand owners. Second, less value in defensive filings. The current situation forces trademark owners to file broadly and defensively, which is costly and cluster the register, causing a depletion of available marks to use and register. Third, easier register enforcement because more factors are to be considered when determining bad faith. We also hope that it will be easier to secure legitimate registrations and there will be greater deterrent effect to pure bad faith squatters and opportunists. Lastly, more sensible allocation of prosecution budget. This means less cost in maintaining defensive registration and bigger budget for market enforcement.
Thanks, Melvin. That's all we have time for today. Thank you for joining, and we look forward to seeing you next time.